Good morning. Anything before the jury comes?
Your Honor, we were informed this morning by the state that there are potentially 7 reply witnesses. And before we get into that, we looked at the cases on reply, including State versus Prather, which is a 2020 case. And I want the court, and I want the state to understand, and we think many of these witnesses have already testified. These very few new witnesses. They've already testified in this case, and they're being called to reply to, the way we read the cases, new matters, new evidence, something. We have a right under the case law, State versus Watson, which is a 2003 case, 353 SC 620, 579 SC 2nd 148, to serve rebuttal. To serve rebuttal. So
You said a right to?
it's discretionary with the court, but I would submit to the court that under the criteria set out in this case, you would determine that if they raised new matters, that we have a right to respond to those. Now, we're told that Dr. Reamer, their pathologist, is going to testify. And if you remember correctly, Your Honor, and I've looked at the YouTube, that's all we can get at this point, which is a video of it. Dr. Reamer's previously testified that she did not believe this to be a contact wound to the head. I submit they're going to try to repeat that testimony or elaborate on that testimony, and that was the only issue that our pathologist raised, but he believed it was a contact wound, and why. She's already testified why it wasn't a contact wound to the head, and why. So are we going to have to get our pathologist back here to counter hers if she raises some new issue? Or perhaps, Your Honor, 7 reply witnesses. It was 2, now it's 4, now it's 7. I mean, this is a process that's got to stop at some point. We're going to be here next week. There are 2 expert witnesses that have already testified in this case. Now, one of them I would concede, Ken Kinsey, they're an appropriate reply witness based on Mr. Palmbeck's testimony yesterday. But the pathologist, again, to testify it wasn't a contact wound to the head, she's already testified to that. And some of these other witnesses, law partner members, to testify what they do or do not remember about the night in question. Again, they've already asked them that on direct in their previous testimony. So this has got to end at some point. We spent 2 weeks on 2.5 weeks of the 6 weeks on financial matters. In my opinion, could have been done in a day. That's just my opinion. But I'd ask the court, as we make objections, to consider and maybe even proffer what they're going to put up before we get in front of the jury, so that Your Honor can make an evaluation before we start down that road for a half-a-day witness that may not add anything to the case. Thank you, Your Honor.
Your Honor, the State's certainly aware of the scope of reply testimony as it relates to the pathologists. There are actually a number of issues on which their pathologists challenge the findings of Dr. Reamer, and she's here to explain why those conclusions are incorrect, including his reliance on particular factors, and why ultimately his conclusions are wrong. I think that's directly in the scope of reply testimony. My focus here on reply is not to just repeat testimony, but to focus on specific issues raised during the defense case, that specific witnesses have something that contradicts or puts that in the appropriate context, and that is our focus. We intend to move very expeditiously through that. But ultimately, as it relates to the pathologist, just like Kinsey, it relates specifically to the conclusions offered by the defense experts. It is not just mere repetition of testimony already received, but comment on factors identified by those defense experts and why those are incorrect.
Your Honor, briefly, let's take Mr. Kinsey, for instance. There was testimony yesterday that our expert believes there were 2 shooters. Obviously, something that he was not asked. Obviously, something that's a new matter. Obviously, proper for reply. But there are minute details, perhaps, that will be these witnesses will be questioned about And simply because there might be a hook doesn't mean they get to go into everything. I mean, this is, again, this was an estimate, 3-week trial. We're now in week 6. This will go into week 7. It seems to me the state's position is let no dead horse go unbeaten. This has got to stop. Thank you.
Of course, the defense, of course, when we had the meeting with Judge Price, at the time we all agreed with that estimate. It was not just the state. I realize this is going long. I intend to move expeditiously, but the state has the right and the opportunity to do appropriate rebuttal evidence to a defense case, and that will be the focus of the testimony here today.
Your Honor, the right they have is the same right I have. It's the right you allow. I just want to make sure he hadn't got a right to do anything. Thank you.
Well, certainly the state cannot retry the entire case, but the state has the right to reply to contradict certain issues presented by the defense or certain issues of credibility. It has to be finely tailored such that we don't create a situation where the court will be compelled to allow rebuttal, which is almost unheard of. You mentioned State v. Prather. That was my trial. I was a trial judge in that case in Lexington County, a murder case wherein I allowed reply testimony, actually by a SLED agent. The Court of Appeals, in a 2-to-1 decision, reversed the conviction. Then the Supreme Court reversed the Court of Appeals and reinstated the conviction that was obtained before me. So it can be a controversial and contentious issue. It almost always is, because there has to be a limit to the back and forth. I'm surprised to hear the number of reply witnesses that the state says that it intends to offer. I do not know. The case is so complex. We've had so much testimony. I cannot sit here in advance and rule as to what would be appropriate and what not. I just have to deal with it on an issue by issue, objection by objection basis. And with that, I say bring the jury.
Jury is present, sir.
Sure, thank you. Good morning.
Good morning.
Day number 26. 26. You have heard the defense's case. Now the state gets an opportunity to reply. And you may call your first witness.
May it please the Court, Your Honor, the state calls Ronnie Crosby.